Welcome to another episode of the SERMAPod. This is the podcast of the Sports and Entertainment Risk Management Alliance. I'm the founder and CEO and the host of the podcast, Rich Lenkov. We are very thrilled to have Rebecca Adelman, who is a SERMA member, also the mother of a SERMA member. We got to give a shout out to Max Adelman, who's one of our favorite new members, who is a prolific author, speaker, educator, NBA agent, and who is the founder of the Adelman Firm PLLC, talking to us today about a very important topic in the space, which is prevention programs, preservation of evidence, and formal litigation hold policies in high-risk industries such as sports and entertainment. Rebecca, thank you for joining us on the SERMAPod.
Oh, it's so good to be here. Really, I've been looking forward to this, Rich.
We have too. So talk to our viewers and listeners a little bit about why we're covering this topic, and then we'll jump into some tips that they can employ in their practice.
Yeah, you bet. In all my years, I'm 35 plus years doing litigation in the space and risk management and high risk areas. And, I can be in a conference doing a presentation on preservation of evidence. And here's what I'll say. How many of you in the room know in your organization about your litigation hold protocols? If there's a threat of litigation, what to do with evidence, what to do with documents, what to do with surveillance videos. And honestly, one person will raise their hand. And so I think that brings up the really important topic of what kind of triggers occur for implementing a litigation hold protocol. But the key thing is like having one, understanding one, and having it formalized across your organization, I think is key. It's one of the most important risk mitigation programs you can have.
It's such an important issue, especially in sports and entertainment, because to your point, frequently when these incidents occur, the people on the ground are not thinking necessarily of litigation. And it's not sometimes an area or a venue that has a lot of litigation, so they're not used to it. And that could lead to a lot of problems. So before you get to those problems, though, you counsel a lot of your clients on how to prevent these issues from happening in the first place. Talk to us a little bit about that.
Yeah, I think the first thing that we do is we discuss what's currently in place. What kind of protocols do you have to preserve evidence if there's a threat of litigation? So we try and see what their systems look like, who their key personnel are that are point people. And then, we help them design a program. We discuss, what a litigation hold letter looks like. What does it look like when, an organization is being threatened with litigation? And, these triggers we'll probably talk about here in a second. But it doesn't necessarily have to be, a letter you get from a lawyer that says, we're going to sue you and preserve your evidence. That duty arises in other ways. And so if there's an anticipation of any kind of litigation, you want to make sure that your key personnel, have some kind of documentation that says, here's what you have to have in order, here's what you need to preserve. These are the protocols we need to have in place. This is how we're going to kind of reduce our liability. And if we don't, there could be some serious sanctions. So we help them design, formal protocols. And like I said, most organizations don't have them. It's a real reactionary position that organizations get into, where they're looking to preserve evidence only after the threat arrives, as opposed to having a program already proactively, where internally, if we know there might be some risk or some anticipation of litigation, we can already implement those protocols. That's the really important thing, I think.
And it's really important for our viewers and listeners to take away a couple things, not the least of which is that you don't have to have that letter for the duty to be triggered, right? It's like some people think, well, I got this letter, I'm going to react. No, that duty exists regardless of whether you get that letter. So it's really important to get on top of this. And you mentioned the duty existing even before litigation happens when there's an anticipation of litigation. Different states look at that differently. I'm in a state, Illinois, that looks at that from a very pro-plaintiff perspective. Mm-hmm. If you don't do that from the beginning, then there are some bad things that can happen. So just give us a little bit more flavor as to when the legal duty arises and what triggers this legal duty.
Yeah, probably just for ease and, out of respect for our time, there's probably three main credible threats of litigation. I think, obviously getting a formal demand or some kind of complaint, or an occurrence that happens that's typically is going to result in litigation, right? Particularly in high risk areas, we represent a lot of these adventure parks. And so, and in these parks, we know if someone's going to slip and fall, someone breaks an arm on one of the attractions, we know that typically is going to result in litigation. And then even media reports, there's case law out there on media reports suggesting an impending litigation, right? Or an impending investigation even. That could be a credible threat of litigation and trigger the duty to preserve evidence. So, and as you say, it's important to check your state, see what your states are requiring. There's some federal law on this, but of course each state's different and when the duty arises, and then what your responsibilities are once the duty is triggered. What do you have the duty to do?
So, who writes the letter? What goes in it? What kind of language do you use? Do you have to be a lawyer to write it? Does it have to be, full of lots of legal sounding phrases? What's ideally in that legal hold letter?
Yeah, I mean, the answer to that really is no. In terms of, does it have to be written by a lawyer? When you're developing a litigation hold program in your organization, there'll be a point person. There'll be someone in your organization that becomes aware or is put on notice of the threat of litigation, and that notice just can go out on a memo. Hey everybody, go across all the departments. Hey everybody, here are all key personnel, our IT department, our operations department, our finance department, whatever it might be, our managers, our operators. An event occurred, an incident occurred, and here's what we need to do. We need to, if we have any, it could be a date time frame, for example, maybe it's an event that occurred over time. We need to preserve evidence during a year or 6 months or on this particular date. That has to do with, save all your documents, save all your records, save all your surveillance video, whatever, all your emails. And if we have, I think this is an important point. If we have destruction policies, some electronic systems have automatic deletes or some automatic destruction protocols. Those need to be put on hold. Mm-hmm. And so it really is sort of a cross-organization effort. So it doesn't have to be anything really legal or legalese. Just, hey, we got this threat, preserve it. Someone's going to be checking back with you and make sure we don't destroy anything.
It's funny. I was on Tuesday. I was speaking at the conference locally here in Chicago. They had a chapter event for the Stadium Managers Association, and someone asked about incident reports. And I told the story of how a former client of mine, good client of mine, used to have on their incident reports until I told them you got to change it. It had a typical incident report asking who, what, where, why, when. At the top of it, in big capital letters, it said, please destroy this after ending it in. I was like, what? What do you mean?
Exfoliate it.
Exactly.
Get rid of it.
That's right. So we changed that document, but it was mind blowing to your point.
And I think one thing people don't understand too is if later on there is some claim of evidence being destroyed, that the document, that legal hold, can be a very important piece of evidence.
Right.
The absence of it is also important. So just having it and just documenting it, demonstrating that somehow the organization made an effort, right, to preserve information will go a long way.
Right, because before the jury, the party that destroyed the document gets the presumption against them that document would have hurt their case and helped plaintiff's case. So that's a missing evidence instruction you want to avoid. All right, there's some case law that we talked about that's really on point. Maybe give us a couple examples of how courts have looked at this.
Yeah, so one of the things we were just talking about is before I got on, I'd forgotten about a couple of really kind of key cases. I don't. There's that Brian Flores, the NFL case. I think he accused the NFL of discriminatory hiring practices and the Dolphins and the Giants. And that lawsuit claimed that evidence, text and emails, I think, relevant to the case had been withheld, and they were leading to spoliation concerns. So that was a really important case. And, I think, if I'm not mistaken, there were some kind of sanctions in that case, but that just brings up just a sort of a high profile case that brings up the point that, sanctions can include these adverse jury instructions you're talking about, or a case dismissal. And so that was really important. That involved, text messages, emails. Those are really hard to, once they're gone, they're very hard to get back. So I think that was one of them. And then we talked about, and I'd forgotten too, about Deflategate and Tom Brady's cell phone. I think, didn't he just claimed that he destroyed his cell phone, and it was critical to, I guess, the issue regarding the underinflated footballs. And so I think that was an important one too. So, and it clearly there was an anticipation. This would be a great one where there was media. The trigger would have been some kind of, there was a lot of media around the fact that there was going to be a big investigation around this. And then the next thing you know, the phone goes, missing. So anyway, just some interesting. And then another, I think, interesting case from a professional sports perspective was the NHL concussion lawsuit. That had to do with medical records and, the destruction of health information. So, and I think that was really sort of key evidence, but I think there were also some HIPAA and some other federal implications on federal regulations that had to do in that particular case.
Yeah, it's very timely and interesting. Now, there's some guidelines that you were referencing from the Sedona conference. Could you tell us about those?
Yeah, so the Sedona conference is a really nice organization, nonprofit organization that does a lot of educational research on complex litigation and antitrust stuff. And they joined, I think it was like in 2019, the conference joined together to really make statements on litigation hold. And they came up with some guidelines. It's really worth, I don't know how the podcast works, but putting a link in there to the Sedona guidelines, because they're very important. We follow them. There are 6 key guidelines. And, guideline number 1, reasonable anticipation of litigation and when it arises. Notice we talked about this, credible threat of litigation. And then your duty to preserve arises. And that second guideline, determining what has to be preserved. And I think that's important. And they give you some really good lists of information. And it really, relevancy, Rich, is the key there. It has to be relevant. You have to save the whole universe of everything in your organization. But if it can be relevant, and it has to be a good faith evaluation of relevance. That third guideline is, taking reasonable steps to identify and suspend features like, automatic destruction policies and things like that. And so the fourth guideline is implementing the legal hold and the coordination. That consists of your legal team, your IT team, could be, your compliance, records management, et cetera. And guideline number 5, monitoring it. You got to monitor it. You think there might be litigation. It could be a year. It could be 6 months to a year, whatever it might be. But you got to continue to monitor and audit the compliance of the protocols. And then lastly, just document. Just document. We say that all the time. Just demonstrate your efforts, your good faith efforts to try and preserve evidence. That would be the top, I think, guidelines. But if you don't have a litigation hold protocol in your organization, have your compliance team go there to the Sedona conference and take a look at it.
So you mentioned working with, inflatable businesses and climbing centers. You and I both do a lot of that kind of work. What do you do if you've got an incident involving a piece of equipment that really forms a huge part of your business, like a trampoline, for example? There might be, that might be the only trampoline in the whole place. Are you supposed to take that out of commission and shut down your whole business? How does that work?
Yeah, that's a really good question. So I got a case I'm working on right now. It's actually in Tennessee, and if there's an incident involving a harm, you got to report it. You have to report it to the to our state. So once you report it to the state, like within 24 hours, you got to submit videos to and show them the video, and they take a look at the video and they see if it's a malfunctioning piece of equipment or not. That's all they really care about is, was it the equipment that caused it? They don't care about anything else other than whether or not the equipment's safe. That's their job. And once you get that back and they say the equipment's safe and it was could have been something else, failure to supervise or something, they're not going to opine about that. You can put that equipment back into commission. If it's the equipment itself, and there's a security issue with the equipment, you got to shut it down. I mean, I don't know what your other options are. I think that is the option, and you got to you can correct it. My recommendation on that is, you get someone to come in, take an evaluation of it, do an inspection of it, take pictures, and then have some remedial measures and get it back in commission. This is really depends on where you are in the whole litigation, where you are in the course of the life of the litigation. But we're oftentimes meeting plaintiff's counsel on site, tearing up foam pits, right? Looking underneath them, seeing what the floors look like, inspecting. There could be photographs, 6, 7, 8 months earlier that we need to produce, et cetera. So that's a really good question. I guess I never thought about, like, if that's your only piece of equipment, what do you do if that's your livelihood? I don't know. It's a great question.
I guess no, thanks. I think we'll end off with some, repercussions, consequences of failing to do this. We've talked about spoliation. What does that mean? Can you negligently, can you be guilty of negligent spoliation? In many states you can. Illinois does recognize, where I am, recognize negligent spoliation. So this is scary stuff.
Yeah, so Tennessee, in my states where I practice, there has to be some intention around the spoliation. And in Tennessee, for example, if you had a reasonable threat of litigation and you destroyed the evidence, spoliated the evidence, and there's some evidence that it was done intentionally, then, sanctions, we got all sorts of sanctions. Some of them are governed by the rules of civil procedure, but, and case law, but fines, the adverse inference instruction you were referring to, a jury can infer that the evidence would have been favorable to the plaintiff. The case could get dismissed. There's all sorts of, much more severe sanctions. I've actually had a case before where, the judge dismissed the claim. And I mean, the judge dismissed our defense and, we were defaulted in a case, but it was pretty intentional. Clearly it was in a healthcare case though. And, records were destroyed, but still, to your point, the importance of these programs and evidence preservation and litigation hold practices can't be overstated because the consequences are pretty significant.
Rebecca Adelman, SERMA member, thank you so much for joining us on the SERMAPod on this very important topic. And please come back, as I know you will, and illuminate us on further topics going forward.
Thanks, Rich. Enjoy being with you.